Thanks a lot, Ivo. Q&A is open for everyone. I hear a lot of echo. I don't know where it comes from. So first question from my side. Do you think that there would have been an ethical way to do this kind of study, for example, by informing the subjects? And do you think that such a way could actually lead to interesting results?
Well, that's the question. I think, the proper way here would have been to contact the responsible people at the kernel, and then talk with them as to how it would be best to implement this. I know that the impact that they expect to have will not be the same, certainly, but I don't think that the way they did it, without basically asking for any consent from the human subject, because I don't think there is dispute on this. This was a project that involved tests on human subjects. I don't think that was the way to go. I don't know whether the results would have been the same. Probably not. Yes, there is an element of surprise that they needed to prove their proof of concept. But personally, I would be against this. I mean, especially not for a project that's as live and as dynamic as the kernel and as critical.
Well, the interesting thing is also that the result of that paper are not actually too exciting, right? I mean, none of their commits did make it anywhere. So if you would choose a lower profile project, a less critical project with less thorough reviews, your commits might make it somewhere, but you would also have much less impact.
Correct. Yeah. Then I think this could raise, I mean, you could try with a consumer-based application or something. You could try LibreOffice, for instance, or something else. But I wouldn't mess really with the kernel. I think it's a wrongly chosen target.
Yeah, but would it be better to do this with LibreOffice? I think for certain companies, this is still critical software that is being used daily. And if you introduce a bug there that is then to some extent abused, if you can ever show that it has been abused, you're still in deep trouble.
You are, no doubt about it.
I see Leonard typing something. You might as well open your mic, Leonard. Yeah?
Okay, can you hear me?
Yes.
Hi, thanks for the very interesting talk. The authors, I think, they proposed as one of the steps, one of the possible solutions, such a I hereby declare that I do not intend to introduce bugs button. I think you mentioned this, right? I was wondering from a legal perspective, like, does this mean anything? Is this worth anything? Like, how would you prove that someone actually intended to introduce a bug if that was the case? And is this something that you think holds any kind of merit, or is it just like one, I don't know, just to make something up?
Not really. Well, it's like a promise not to commit a crime. You still have to exercise due diligence in what you do, and by all means, software development has high due diligence standards. I mean, we now have the tools to make sure, and we now have methodologies to know whether what we are doing is right or not. I mean, there is no set in stone standard of due diligence when it comes to software development, but you cannot just do whatever you want. And if you ask me whether such a clause would be enforceable, I think it would meet the fate of the other clauses that I mentioned from many of the open source software licenses that we have. It's at least in the EU, it's hardly enforceable. And it's a personal opinion of mine that I don't think these clauses at all belong in licensing agreements, because licensing agreements aim to deal with issues that concern copyright and how you use and how you operate with the copyright of someone else. It's not really the place to deal with questions of liability.
Are you aware of studies with a similar focus in that whole field of usable security and so forth? I mean, the question of how to assess whether people do security right is not new. I'm just wondering if there's been work in that direction before.
There have been some studies, but actually the question of what is the due diligence standard of a software developer is not yet answered, and it's part of legislation that is being discussed in the US specifically, not so much in Europe. And it's a prominent field of research, one that especially legal scholars have not have not written so much about, to be honest. There are papers which discuss product liability, but they never go into in depth. They never check what the standard of due diligence from expected from a developer should be, and based on what. So this would require an interdisciplinary study to be done properly. Otherwise, we're just talking in the abstract as to, because the law operates with some very abstract due diligence standards, which when applied to a context can mean something very, very concrete.
Yeah. Questions from the audience, anyone? Don't want to be the sole entertainer here? Are you exploring this field further in your PhD or in your work at the moment?
To be honest, not really, not at all, in fact, because it's just something that got me really interested at the time, and I thought, okay, I just want to see what others think of it and how it's perceived generally in the community, especially in the research community.
And is there European legislation coming up to deal with due diligence in that field?
There isn't really. There isn't really. There was a proposal for revision of the product liability rules, but none of them concerned the potential for creating a safe harbor for developers or researchers. The thing that I mentioned from the open source software and hardware study, it's one of the recommendations of these studies that there is a need for creating a safe harbor for open source software project committers, because it's an area of great uncertainty, and while so far it hasn't caused issues, I think papers like Hypocrite Commits show that there might be issues, that it's not just all purely theoretical, and that lawmakers also need to think of it. But no, in the EU, I wouldn't say no, there isn't.
Mm-hmm. Okay. There's a question coming up, I think.
I can also maybe go back to the discussion questions that we had here, in case that inspires someone to chip in.
I find that the last point 4 interesting, the no-go boundaries for safety critical projects. I mean, how it's difficult to say whether a project is safety critical in the safety critical sense of the word when
Yes.
we're talking about open source project, because sometimes it might be an image processing library that leads to something disastrous. Huh? So
I think it's becoming more and more difficult to define safety critical. Obviously, we have formal definitions, but
yes, exactly. So we have formal definitions. We have things that the Safety Critical Systems Club is working on, and they are all in aerospace and rail and things like that. But of course, an open source project might be used in all kinds of ways, and it's often very hard for a researcher in this case to assess whether they are working with a safety critical piece of software. Dominique is asking whether there have already been legal cases where liability of open source authors have been tested in one way or another.
No.
Not at all.
Not
Okay.
at all. There are hardly any cases, even from the licensing field of things. I think we count a total of 7 to 8 cases involving GPL, and that's it basically. But there haven't been cases, no. See, even if there is, many of the maintainers we are talking about and contributors work for companies, actually. So it would be the companies that would deal with any such issues, probably, I would assume, through settlement and so on. So things would rarely make it to court.
Yeah, I see that. That is true, yeah. Does that change anything about the liability?
Well, it does, because you would basically waive your right to seek damages from a court. You would agree that somebody pays you something, and the deal is done. You no longer want a court to pronounce as to who was at fault, whether there was fault, whether someone did not meet or live up to the due diligence standard they are expected to, and so on. So from a research perspective, it's actually very sad when a case is settled outside of court, because you don't know what the actual implications would be. And in fact, that's what happened in the US with the Spectre and Meltdown. There were a couple of lawsuits based on Spectre and Meltdown and the fact that they reduced the performance of computing devices that consumers purchased, apparently with different expectations. So they tried to argue in court that because of this and because they reduced generally the security of their systems, that they could claim damages. That was a case against Intel, but as far as I remember, it was again settled and it never made it into an actual judgment.
Yeah, I see. Okay. Another question from Dominique. I've almost missed it. What would you expect to happen if a company tried to sue OpenSSL contributors, individuals or their employers, for example, Heartbleed?
That's interesting.
Is it a question of whether you introduced, whether you did something wrong in good faith versus intentionally, or what would be the question there?
So the potential for a legal dispute in this case would be negligence. I thought so too.
Yeah.
That they could argue negligence. Well, it would be very hard to argue negligence because at the end of the day, it was the company that chose to use the OpenSSL library, right? It could have said, well, I'm simply going to fork the project and do my own implementation of this. And then the original contributors to the project, they don't have much to deal with how you use the project with the product in your supply chain. Now, whether you can sue directly the contributors, I don't believe so, because you're not in a contractual relationship with them, not directly at least, and it's also a question as to what the license you agree to when using the project means in legal terms. And what do I mean by that? The GPL, for example, is universally, not universally, but at least in the US, it's universally considered as a license. So that means it only deals with copyright issues, generally speaking, and that whatever you have in there is governed by the rules of copyright law. Now, there have been cases in Europe, one very recent actually from France, where a French court said that, well, the GPL is actually a contract. It's not a license. And if it is a contract, that means that the rules of contract law, including the rules on negligence, for example, would apply to this contract. And then the interesting question here is, because the case was actually a copyright case in the end. It wasn't a liability. It wasn't a tort law case. But if it were, does the fact that the GPL is treated as a contract by European courts mean that if you have a liability clause in there, that this clause could be enforced somehow, because it then creates a contractual relationship between the OpenSSL maintainers and you as a company using this project. So if they say we are in no way liable to you, but the rules of contract law say, well, you cannot say this because there are certain minimum levels beyond which you cannot go. You simply cannot exclude all liability. That would be an interesting case, but I don't think we're going to see one.
Yeah, interesting. Okay. Are there more questions from the audience? No, it doesn't look like it.
No.
I think we have a lot of food for thought now. Ivo, thanks a lot. We can collectively clap if anyone wants to try. It usually doesn't work out very well.
Thank you.
Yay!
And of course, I just wanted to say that if any questions pop up, or you just want to touch base or talk about this, here are my contact details. You can connect, and I'd be happy. As I said, it's not the core of what I do, but it's an interesting area, and I'm willing to talk about it.
Yeah. So Ivo, then thanks a lot for the inspiration and for the food for thought and for sharing your musings with us. Let's see how we can take this further and what impact it has on our next attempt to break whatever open source project.
Yes.
Thanks a lot for that. The next seminars, I'm just posting the website quickly. The next one is going to be in 2 weeks already, I think. So on the 21st of October, which is also a Thursday, same time and place, Elissa Redmiles from the Max Planck Institute for Software Systems in, is it Stuttgart or is it or is it Saarbrücken? I always confuse them. Is going to present work on sex work and technology, lessons for the internet governance and digital safety for sex workers mainly. So that's going to be again an interesting one on the intersection of law and technology, and I'm really looking forward to that. I wish you all a wonderful day. Thanks a lot for Ivo and for the people interacting here. And see you in about 2 weeks with the next seminar.
Thanks, everyone. Take care.
Everyone.
Have a good day.
Thank you.